fine. No, totally fine.
Okay.
Great. So, hi everyone. I am Stephanie Haynes. I'm the director of Philadelphia Family Pride. We are the LGBTQ plus prospective parent and grandparent group here in Philadelphia, and serve families across the city as well as in the suburbs, Delaware, Southern New Jersey. People definitely access the stuff that we do from all over. And we're really excited tonight to be holding our second in a series, kind of a summer virtual series of free workshop classes on what we call Maybe Babies. So basically classes for prospective parents and folks who are already parents wanting to expand their families. Last week we did assisted reproduction. If you are interested in checking that out, there's a video on our Facebook page under videos of the first portion of that with the presentation from a reproductive endocrinologist or fertility doctor and someone from a lab director from the Fairfax Cryobank, and then the Q&A from that. So you can watch that. And then, like I said, we're recording tonight, and then we'll post this one there as well. Next week, we have adoption options, which Taylor, if I'm not mistaken, is on Wednesday night, also at 6. So we're going to have someone from a private adoption agency, someone from the statewide adoption network, who can talk about kids in the foster care system whose parental rights have been terminated and are up for adoption. And we'll just briefly talk about international adoptions as another option. So if you have legal questions about adoption, tonight is your chance to ask those, and then next week we'll have the adoption professionals who work in that field. And the rest of the schedule we will send to you. So Taylor has your email address since you registered, and we'll send you the rest of the schedule, and you can register for the other sessions. Oh, thanks, Taylor. Just posted the video for the chat. Good teamwork. So I don't want to talk anymore. So I'm going to turn off my video and audio, and I'm going to let Becca take it away. And remember, you can ask questions in the chat, and then Taylor can ask the questions. But again, since we're a smaller group, you could turn on your audio and video for the question portion, but just remember, we're going to record through the Q&A after the presentation, and then we're going to turn off the recording and have the parents be able to talk, more privately, and then we can continue doing Q&A for that portion too. All right, thanks everybody.
Okay, great. And just so again, I'm Rebecca Levin Nayak. I'm an attorney at Jerner Law Group. I've been there for just about 10 years. My practice is family law, adoption, and assisted reproduction law. For some reason, just before I get started, I cannot see the chat, but I do want this to be conversational. So Taylor, if you see something come up on chat, can you let me know?
No problem. So you don't need us to wait until the very end for Q&A?
No, I'm happy for people to ask questions as they come up. So I know that I'm hitting on what people are interested in, and know that, it's a little weird to give a presentation to like all blank screens. So, so it'll remind me you're still there too.
Okay, no problem.
Okay, great. So, yeah, so I do adoption and assisted reproduction. I think in the questions that people sort of said they were interested in having answered, I think that I'll touch on most of those in this. This presentation is focused a lot on assisted reproduction technology and the law associated with that. But, we can certainly have time for adoption questions too, and I will definitely talk about step parent and second parent adoptions. When we talk about third-party reproductive options, we're talking about egg donation, whether that's a known egg donor or unknown, embryo donation, sperm donation, co-IVF, so where one parent carries a pregnancy and another parent gives genetic material for that pregnancy, and gestational surrogacy, so where a person who is not an intended parent carries the pregnancy for intended parents. So what's an intended parent? An intended parent is a person who wants to be a parent and uses some sort of assisted reproduction. They can be biologically related. For example, in the case of a gestational carrier, one or both intended parents, or none, may be genetically related to the child. So an intended parent can be genetically related to a child, but does not need to be. An intended parent who is not genetically related to a child that they're conceiving, or in some cases, even a genetically related intended parents, will need to take additional steps to make sure that they are also considered a legal parent. So a legal parent is important because a legal parent has certain rights and responsibilities that not every intended parent has without formalizing that legal relationship. So for example, there's no question that a legal parent has right to custody, is able to make decisions about their children's health, education, and well-being. They also have financial responsibilities to their child. A parent-child relationship has inheritance rights associated with it, federal benefits such as Social Security survivor benefits. And so all of those are really important to make sure that the legal parent-child relationship is confirmed. So when we say donor, there's no statute in Pennsylvania governing assisted reproduction technology. Everything that we have in Pennsylvania is established through case law. And so unlike some of our neighboring states, if you live in, I practice in Pennsylvania and New Jersey, so if you have New Jersey questions and you live there, let me know. But unlike New Jersey, for example, we have no parentage statute. So everything's been developed by case law, but we do have really good case law. And what the case law in Pennsylvania says is that donor contracts are enforceable. There's a pretty old Pennsylvania Supreme Court case. It involved a woman who conceived twins using sperm from her ex-boyfriend, and it was done through clinical methods with a doctor. They had no written contract, which I would recommend having a written contract. They didn't happen to have that, but they had an oral agreement that she would be the sole legal parent and he was a sperm donor. And then 5 years later, she sought child support. And what we got out of that case was, the Supreme Court of Pennsylvania said that no, he was a donor, not a parent. He has no obligation for support, and that donor agreements are enforceable. So that's a really great case that said we can contract as to who would be an intended parent, so, and who will not be an intended parent even when they have genetic connection to a child. So how does a intended parent become a legal parent? That can be through court order, contract, or adoption is sort of the main forms. Again, a contract, I would not rely on a contract alone because the law of each state varies and contracts are not always upheld in every state. There's a lot of interpretation under state law, but adoption and parentage orders, and I'll talk about those more. So one question that I get a lot is, what is the relationship between people being married and being a parent? That if you are married and your spouse gives birth to a child, are you a legal parent? And this goes back to this idea of the marital presumption of paternity. And paternity is that legal fiction, it really came up before genetic testing, that a man who is married to a woman is the father. And this varies from state to state, but that idea that marriage creates a legal parent-child relationship is there in case law, that there's a presumption that if a couple is married and one person gives birth to a child in that marriage, that the other person is also a parent. But the problem with relying on marriage alone is that it is a rebuttable presumption. So what can rebut the presumption? Not having a genetic connection to a child. And so that is where, for many same-sex couples, one person may not have a genetic connection to the child, and that presumption could be rebutted. The other issue that comes up in sort of the development of case law is that the presumption of paternity is only applied in the case law to an intact family. So if a family is going through a separation or a divorce, that presumption cannot necessarily be relied on, that it's much weaker or almost non-existent in how the case law discusses it. But one interesting thing is, despite the fact that the marital presumption does not give rise to legal parentage, being a legal parent, the marital presumption will allow the birth certificate to be issued in the name of both spouses. So if one spouse gives birth, regardless of whether the other spouse has a genetic connection to the child, both names will go on the original birth certificate. And this comes most recently from a actually United States Supreme Court case called Pavan, where they said, well, we don't do genetic testing for opposite sex couples. We're not going to, it would not be fair to not put both spouses' names on the original birth certificate if they're a same-sex couple. And so what we got out of that is, throughout the United States, no matter what state you're in, if a couple is married and a person gives birth in that couple, both names will go on the original birth certificate, but you still need more to determine that you're a legal parent. And unfortunately, in my practice, sadly, more than once, more than 5 times, I've seen people challenge their spouse's parentage, even when we have a birth certificate naming both people on it. And of course, it's not just for the scenario where people are ending their relationship, but other things as well, such as Social Security. So how does an intended parent become a legal parent? Well, there's some work that we recommend doing pre-conception. For co-IVF, where one parent is carrying a pregnancy and another intended parent is donating genetic material, we actually will do what's called an intended parents agreement, because in that scenario, there's an argument that could be made that one person is an egg donor or one person is a gestational carrier. And so the co-IVF agreement says, no, that's not what's going on here, that we have 2 people and they are both intended parents. Another thing that we will do, if there's any donation of genetic material from a known donor, be it an egg donor, sperm donor, or embryo donor, if we have a known donor involved, we'll do a known donor contract. For people who are using a gestational carrier before the embryo transfer, we will need a gestational carrier agreement in place. And for many of these, the clinics, if you're working with a clinic, they will actually require confirmation. They'll have me actually send a legal clearance letter to confirm that, yes, there's a contract in place, everyone is on the same page as to what's going on, who is a donor and who is an intended parent, and that's in place before, be it an embryo transfer or conception with donor sperm. And then there's post-birth work. In a gestational carrier situation, we'll actually get a pre-birth order. So we'll be able to petition the court to enter an order that allows both intended parents' names to go on the original birth certificate, and that the gestational carrier's name will not appear on the birth certificate at all. The other post-conception work for the scenario where one intended parent is giving birth, even though both names go on the original birth certificate, we strongly state that's not a legal determination of parentage, and a second parent adoption or step parent adoption confirming parentage is really essential to make sure that both people are on equal footing. And the difference between a second parent adoption and a step parent adoption is, we call it a step parent adoption when a couple is married, even though that seems like a strange term, because it's not a step parent adoption. Both people are the original parents, but it falls under that same statute and the courts use that same procedure. Second parent adoptions, you don't have to be married to be to adopt, and so we term follows basically the same procedure, but we call it a second parent adoption. But what I really like to call it is a confirmatory adoption, which is not a legal term, although it's sort of used colloquially for these situations, because you're not adopting, you're confirming the parental rights that as an intended parent through the legal process of adoption. So one thing that's really important as to why adoption is so important is legal parentage is governed by the state where the child is born, or if a child moves to a different state where they've been for the most recent 6 months. And so even if you are giving birth in Pennsylvania, where we have we have very strong case law on the enforceability of donor agreements and things like that. If you were to move to a different state, their law could be completely different, and parentage could be in question. I already talked a little bit about the preconception work that we're looking to have: preconception, a donor contract, an intended parents agreement, or a gestational carrier agreement. One thing that I will mention is that be really careful if you're working with a clinic and they present you with clinic consent forms, that you read them and that they represent your actual intentions. For example, in a co-IVF case where one parent is carrying a pregnancy and another parent is donating not donating, but it's their genetic material. There have been cases where people have signed clinic forms that don't match with what their actual intentions were. So for example, there have been cases where a woman is carrying a pregnancy, she's an intended parent, but the clinic had her sign paperwork that she's a gestational carrier or something like that. And that can be a real problem because the clinic forms do have legal significance. I've actually, in contested parentage cases where one person's saying that another person's not a parent, I've actually relied on clinic consent forms when that's been the best evidence available to establish that there was an agreement that both people were going to be a legal parent. Certainly you don't want to just rely on that, but those forms do have legal significance, so make sure that you're looking at them carefully and understand what it is you're signing. So donor contracts, if you're using a known donor, you really need to have, like I said, a written agreement. The agreement goes through all rights and responsibilities. It will also talk about what you might be doing if you're storing any genetic material, what happens with that. It might have some lifestyle restrictions to make sure that a donor is not engaging in risky behavior immediately before making a donation. If it's a compensated arrangement, the agreement will have that in it also. And so there's a range of things that go into those contracts. And like I said, those contracts are done prior to conception. Also, counseling is available, that there's some psychologists that specialize in just this type of thing. So it's really important that everyone has the same expectation going into it. Because there are situations where, maybe, a donor is thinking that they might be more involved in parenting than what the intended parents think. Maybe, there's certainly situations with, 3 intended parents in a co-parenting relationship. And so it's really important. And sometimes there's, not that expectation, but there's an expectation for for some type of continuing contact. That's not something that I would put in an agreement, that there would be an enforceable expectation of continuing contact. But those are things that really should be talked about prior to conception as well. And so there are therapists who specialize in that area and can sort of, talk about different things, like what will the child's relationship be like with any child of the donor? How will a relationship be disclosed to the child who is able to do that? Usually that's the intended parents, but it's important to have all of those things fleshed out from the beginning, even prior to conception.
Becca, real quick,
yes.
Could you go over again, like the moving states and the implications for that?
Yeah, so every state has different laws. I only practice in Pennsylvania and New Jersey, so although I have like a gist of what's going on in the rest of the country, laws vary. For example, in New Jersey, for their statute regarding who is a donor actually requires a doctor to be involved, and that if you do an at-home insemination, that it doesn't fall under their parentage statute. So it's things like that, that the law really varies, that you could find yourself in a state that really has many restrictions about donors and what you need to have in place and whether a contract is even enforceable in that state. And so that's why that even if you have a donor contract in place, which, you know, the case law is very strong that those are enforceable in Pennsylvania, that it's really important to do the adoption, because the adoption is universally recognized. That there's actually a United States Supreme Court case called VL versus EL that says, you know, adoptions have to be given full faith and credit in every single state. So every single state has to recognize an adoption from another state, whereas there's not that same type of directive regarding assisted reproductive technology and donor agreements. So I think I answered that question. So this is, you know, talking specifically, the slide is about donor sperm with one intended parent and one genetic parent. So this is a situation we see a lot where there is donor sperm and one genetic parent who gives birth. Like I said before, if the couple is married, both names will go on the original birth certificate. For unmarried couples, both names will not go on the original birth certificate, but if you do the second parent adoption, we'll get an amended birth certificate after the adoption. And so just in case people, you know, you don't have to get married to be on the birth certificate. You do to be on the original birth certificate, but that's something that if you know, are not wanting to get married for, you know, all the considerations that people may not want to be legally married but still have children together, that's not essential, and it'll just be after the adoption that we get an amended birth certificate. But again, birth certificates are not legal determinations of parentage. Gestational carrier contracts. So these are pretty lengthy contracts that address any number of issues, from, you know, what medical screening the gestational carrier will have, that there would be psychological testing. It will talk about the number of embryos to be transferred, you know, health insurance coverage for the gestational carrier, how health care expenses will be reimbursed during a pregnancy, really difficult issues like selective reduction and the possibility of having to terminate a pregnancy for, you know, whatever various reasons, making sure that the carrier and the intended parents are on the same page with that. It'll talk about, you know, what medication the gestational carrier can and cannot take, what people are, you know, are able to disclose about each other, about the contract. It will have, usually there are a number of insurance products that the intended parents obtain for the gestational carrier, such as life insurance, disability insurance, even loss of reproductive organ insurance is pretty much in almost every agreement. And it'll make very clear, you know, extremely clear, that the gestational carrier is not a legal parent, that the intended parents are the parents, and will say that, you know, prior to birth, a pre-birth order will be obtained so that the intended parents go on the original birth certificate. So those are, you know, pretty lengthy contracts because of all the things that can come up with the pregnancy. So like I said before, donor contracts are enforceable. I spoke about the case Ferguson versus McKiernan. Another case that was one that my firm actually took to the Pennsylvania Superior Court was a case called In Re Baby S. This involved Sherry Shepard, who I didn't know until the case, but she was on The View and I think some other TV shows. And she and her husband had a pregnancy using a gestational carrier and an egg donor. So she did not carry the pregnancy or have a genetic relationship to the child. It was her husband's sperm that the embryos were created with. And midway through the pregnancy, her and her husband split up, and she decided that she no longer wanted to be a parent to the child that had been conceived and that she had entered you know, an egg donor agreement with, for a gestational carrier agreement for. And so what we got out of that situation was a case that said gestational carrier agreements in Pennsylvania are enforceable. And so that's a really great case. And it was, you know, a superior court case and the Supreme Court case, said that they weren't going to hear it, which means that the superior court case is the law of the land in Pennsylvania. One caveat: traditional surrogacy is surrogacy where where the carrier's own egg is used, and that doesn't fall under the same law as gestational carriers. It falls under the adoption laws instead, that if you're using a surrogate who is also their egg, we actually have to proceed post-birth as an adoption. Okay, so post-conception legal work would be either the pre-birth order or a second parent adoption, as I said before. So if it's a married couple, it's a kinship or step-parent adoptions, and they're filed after the birth. So what we do at our firm is I generally tell people, come to us second trimester. We'll get all the documents that we need to present to the court, because there are numerous documents that it falls under the adoption law. And so sometimes they may seem a little bit, invasive in some ways. We need to get the adoption, clearances that are required, which are child abuse clearance, Pennsylvania criminal record check, FBI clearance. And if you've lived in more than one state in the 5 years, we may need clearances from the other states also. So we work to help you get those clearances before the birth, so you don't have to worry about it after the birth, and we can have everything lined up to submit to the court as soon as the child is born and we have the birth certificate, so that the time between birth and the adoption is as short as it can be, which prior to COVID, I would say was maybe we were getting court dates in Philadelphia, 6 to 8 weeks after filing a petition. And now, we're just saying how we're getting into the swing of things, but I'm hoping that we'll be back to that normal time frame pretty soon. Like I said before, unmarried couples can file a second parent adoption. That's the law in Pennsylvania, but it is not the law in every state. That in some states you cannot do a second parent adoption if you are unmarried. So I spoke about birth certificates, that birth certificates are simply an administrative record of information reported at birth and are not a legal determination of parentage. I think I covered this slide already, so I will end there. And Taylor, are we having other people speak or opening up for questions now?
We can open up for some questions specific to you now while we wait for our parent panelists to hop on.
Okay, I'm going to stop sharing my screen. There we go.
So we don't have anything in the chat right now. Why does it say that I'm waiting to join this meeting? Sorry. So we don't have any questions right now. But we have a couple of questions that we put in here.
Okay, sure.
So let me see, just some like general questions, I guess. I think you touched on this, but just to clarify, is it enough if my name is on a birth certificate, or do we still need to do a second parent adoption?
Yeah, I think that's a good question, and I think I covered that a lot, but it can't be said enough. A birth certificate, it's sort of my mantra, a birth certificate is not a legal determination of parentage, and so definitely it's needs to be more than that to make sure that you have legal parentage that cannot be challenged, that's good for every purpose, be it Social Security or anything else, custody.
Okay. And then, okay, kind of similar. Oh, actually, never mind. Someone put something in the chat. You mentioned the necessity of including a medical professional for second/step parent adoption in New Jersey. Is that the same in Pennsylvania?
So that's the answer to that is no. And I would say that in New Jersey, it's to fall under their parentage statute. So if for some reason, you live in New Jersey and you want to do an at-home insemination without a doctor, you can still do the adoption. You're just not going to fall under their parentage statute from having the law that apply to you being a parent legally from day one. In Pennsylvania, that's not the same that because we don't have a parentage statute. What we have is a body of case law saying that donor contracts are enforceable, that you do not need to use a medical professional or in Pennsylvania to have an enforceable donor contract.
Would it make it easier to do the second or step parent adoption if you had a medical professional involved in Pennsylvania?
No, I would say it's about the same. When we do file the second parent or step parent adoption, we'll include an affidavit from, if there's a cryobank, we'll include that. If there is a donor, we'll talk about how the known donor was involved. And if there's a physician who did the transfer or a midwife, we might have we would have an affidavit from them as well. But if it's an at-home insemination, we'll include those facts, and it's not any harder or any less enforceable to move forward under those laws.
Okay, great. And do amended birth certificates look any different than original birth certificates?
No.
Does anybody have any more questions specifically for Becca before we turn it over to the parent panel? I'll give one last call. Okay, so I'm gonna stop recording now out of respect.
Oh, I see a couple of questions.
Oh, yep, never mind. Thank you for pointing that out. Is there a recommended rough budget that couples should plan to budget for all of the legal costs?
Yeah, so I think things vary. I would say so it varies on what type of agreement you're doing. I would say, donor agreements are under $1,000 when we do them. Embryo donors or egg donors can be a little more than that though. But generally sperm donors are under $1,000. The adoptions, once you have all the court costs for a step parent or second parent adoption, that is somewhere usually around $2,500, including all the court costs. And if you're in New Jersey law just got simplified, so it's even less expensive to move forward in New Jersey, because for scenarios where both intended parents are on the original birth certificate, if you're married and you're on the original birth certificate, New Jersey just passed a law streamlining their adoptions, so where you're not where they eliminated the requirement for clearances. And so we're able to do those really streamlined. They also, in New Jersey, eliminated the necessity for an in-court appearance. So they're actually being able to be granted on the papers for confirmatory adoptions in New Jersey. And right now, at this moment in time, Pennsylvania is doing, Philadelphia is doing video court appearances, and I'm not sure how long that will last, but that's the case right now.
Okay. And how much do the legal expenses for step parent adoption cost?
Yeah, so that's what was the number where I said
okay.
Just like around $2,500.
Okay. All right. So now is the last call for any more questions specifically about law for Becca. And then we will kind of move it over. We have one parent panelist that's on now. Stephanie will be back on. She can also speak to a couple things as well. Okay, so I'm going to stop recording.